This thing on? Oh my, ladies and gentlemen, it's Catterday. It's Catterday, and I am Lone Wolf Oozle, and we have a crazy case on deck for you today. It's full of all the good stuff. You've got feuding neighbors, you've got conspiracies, you've got, I don't know what else. Here, let me do this for you. You've got craziness is what you've got. You've got bad mouthing, you've got an angry judge, and it just keeps getting worse. Ladies and gentlemen, we got Judge Johnson on deck with us. After Judge Johnson, we're gonna visit with two of my favorite judges from Kansas, Judge Ricky and Judge Webster, because they both had some very interesting things happen for them too this week. So buckle up, ladies and gentlemen. we have a brunch full. And you know how it happens. You know how it happens every week. Same wolf time, same wolf place. We're getting ready to do it. We're getting ready to do it right now.
Case number 25S00523 FY, people of the state of Michigan versus Toby Rose.
Yeah, okay. Toby Rhodes. I'm standby counsel for Mr. Rhodes for disciplinary reason.
Okay, and for the prosecution?
Shot on behalf of the people.
Don't think.
Your Honor, I would just, as the courtroom requires, inquire to the defendant as to the charges he's charged with, so he's aware of the maximum punishment and whether he continues to wish to represent himself with the same evidence.
Okay, I'll ask him. I think we know the answer. Okay, Mr. Rose, you understand what you're charged with. It's not our first day here, but you're charged with assault with a dangerous weapon or felonious assault. It's a felony carrying up to 4 years and a $2,000 fine. You do have a count 2 ethnic intimidation carrying up to 2 years and a $5,000 fine. And you're here today to have a preliminary examination on both of those charges, which is a hearing where the prosecution has to show the threshold burden of proof, probable cause to believe each of those crimes were committed, probable cause to believe you were the one who likely committed those crimes. And if I find that they met that burden of proof, I send the case over to circuit court for trial or further proceedings. If I find that they did not make the burden of proof on one or both charges, then one or both charges could be dismissed without prejudice, at least, and at this point. And then they would have an opportunity to regather themselves and rewrite it if they wanted to. So you understand what you're here for today. Okay. And so, Mr. Mezzi, you asked for some standby counsel, and somehow we found a way to find standby counsel because MIDC, Michigan Indigent Defense, does not appoint standby counsel. So we had to kind of do it ourselves. And we got Mr. Mezzi to represent you. Do you still wish to represent yourself? Or would you like Mr. Mezzi to be the lead counsel for you, since he really knows what he's doing, and you may know some things, but you're not a lawyer?
Okay, and just for the record, I'm familiar with Mr. Rhodes. I don't know if he remembers me, but I represented him years ago in a matter in front of Judge Richards. And I think it was a pretty successful situation there. So if you would like me to represent you, I would be happy to represent you in this case and even going forward. But it's definitely your choice, Mr. Rhodes.
Yeah, I have no problem with that.
Okay.
I do want to cross-examine
Yourself, or I mean, I can cross-examine on your behalf just as well.
See, that's the way it works. If you want him to represent you, you got to trust him that he's going to cross-examine.
Okay.
And then, of course, if he doesn't ask a line of questioning that you would like, you can do a little sidebar conference with him, and he can talk to you about if he thinks that's the best strategy. Because sometimes lawyers have a strategy that's a little bit different than what you might think. And asking certain questions may open up a can of worms that they don't want to based upon their strategy. So it's always good to confer with your lawyer before you say, you got to ask this, you got to ask this. And they're usually very open to speaking with you about whether or not they're going to ask something. And sometimes they do ask it. But that would be what you'd have to do, is give up the right to be up there yourself, asking those questions if you would want him to do it. Okay. You good with that?
Yeah.
Okay. So, Mr. Mezzi, we would have you fill out an MIDC appointment form, and we could send it to circuit and ask that you be appointed for this.
My suggestion is I'll do that. I'm going to ask the court for maybe a 20-minute break.
Sure. So you can.
A few things with Mr. Rhodes, so I'm pretty familiar with how he wants to proceed here.
Okay.
And we can address that.
How many witnesses do you have?
I'm probably gonna be able to do this in just one.
Okay.
Let me just.
All right. We just need to get it done by noon. So Mr. Shockley has a big exam for the afternoon. All right. We're going to pass the roads matter. Okay. Recall case number 25S00523FY. People State of Michigan versus Toby Road.
Shockley, we have the people.
Good morning, Your Honor. What we met penalty had Toby Rose, he's present for the preliminary examination.
Okay, Mr. Rose, your name for the record.
Toby Rose.
All right. And today is the date scheduled for the preliminary examination on the charges of felonious assault and ethnic intimidation. Any preliminary matters?
Or ask for a mutual sequestration order, notating, besides from Austin in charge, notating that the courtroom is presently empty.
Yes. Any objection? Okay, sequestration is granted mutually. But we will stop anyone who comes in if they are connected to this matter. We'll ask them to step out and remain out. Right now, the courtroom is empty with the exception of staff and probably your first witness. Let's see.
Discretion.
Okay. All right. Is there anything on behalf of the defense?
No.
Preliminary.
No, we're ready.
Okay. All right. So,
Just for the record, I did present the court the appointment of the class form. In this.
yeah, I just signed it and wrote a note to ask them to please assign you since you were already here at standby and now will be taking over as counsel of record.
Thank you, sir.
Okay. Get myself together here. All right, you can call your first witness.
People call to the stand, me, your boss. Before you sit down, please look at Judge Johnson and raise your right hand.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth? Thank you very much. Have a seat and keep your voice up a lot louder than that yes, so that we can hear you towards the back door. Okay, thank you. Mhm.
Sir, will you please state and then spell your name for the record?
Three Chavez, TZVISCHABES.
Mr. Chavez, I would like to direct your attention to the date of May 18th, 2025 at around 2:30 p.m. Do you remember where you were at on that date about that time?
Yes,
Where were you?
walking on New Jersey Street.
Were you in the area of the residence of New Jersey Street?
Yes,
Is that in the city of Southfield,
yes,
county of Oakland?
yes.
What were you doing in that area?
Taking a walk.
Is taking a walk in that neighborhood something you regularly did?
Nice days, yes.
On that date, about that time, according to that address, did you come in contact with someone by the name of Toby Rhodes?
Yes,
Do you see that individual presently in the courtroom?
yes.
Will you please point and identify an article of clothing that he's wearing?
Brown jackets.
Your Honor, may the record reflect the proper identification of the defendant in this matter?
Yes, order.
Thank you, Your Honor. Did something, let me ask you this, previous to this date, have you ever met Mr. Rhodes?
No,
Did something happen between Mr. Rhodes when you walked in front of that address?
yes.
What happened between you and Mr. Rhodes?
As he was working on the sidewalk, I was walking past him, and after I passed him, he was holding an angle grinder, and
A what?
angle grinder. He moved forward. He went towards me with an angle grinder being powered on.
Let me stop you there for 1 second. When you walked back past him, was he directly on the sidewalk, on his driveway? Where exactly was he?
I don't.
Okay. Did he have this angle grinder already in his hand?
Yes.
When you were walking up to him and proceeding to walk behind him and past him, were there any words exchanged that time?
No.
Did you say anything to him?
No.
Did he say anything to you?
No.
Did you touch him in any way?
No.
Okay. Were you just walking down the street?
Walking down the sidewalk.
Okay. And then you used the term an angle grinder. Let's take what a mark as people's exhibit 1 there. Approach your honor.
Yes.
Thank you. What is this a picture of?
An angle grinder.
Is that the angle grinder that was used against you on that day?
Similar for sure. I cannot
It's just not,
identify it.
it's just not positive.
Definitely, I don't know if it was the company Bosch. I don't remember which one it was, but definitely had the exact same description.
If I told you this was the angle grinder, would you have any?
Yeah, I was
No.
the prosecutor is testifying. He's asked him if he knows that this is the angle grinder that he saw. He's answered. The prosecutor could not testify.
I'll sustain that. You want to ask it a different way? You could just ask him another way rather than you telling him what it is.
Based on your experiences that day, do you believe this is the angle grinder?
Yes.
I will move to amend people's exhibit 1.
Okay. Any objection?
Yeah, and I'll object because the witness has testified that he doesn't know if that's the angle grinder. The witness is clearly not certain, and he speculated that's the angle grinder. For that purpose, I would object to the admission of that exhibit as the angle grinder used in this case.
All right.
Allegedly used.
If you're supporting that objection, I can lay a different foundation.
Okay, go ahead.
Thank you, Yon.
Sustain.
You agree with me? This is an angle grinder.
Yes.
Okay. Does this look similar to the angle grinder that was used that day?
100%.
And you're just not positive whether it's the exact same angle grinder.
Correct.
When people would move this as people's demonstrative exhibit 1 to exhibitize what an angle grinder is allegedly used against them.
Any objection?
No objection to that.
Sustain. All
Thank you.
right. So this has been admitted as exhibit 1. Okay.
Upon walking past him on the sidewalk, did he approach you?
Yes.
Okay, what happened upon him approaching?
He walked towards me with his angle grinder and powered it and walked toward me.
When you say powered it, what do you mean?
So when you press the button, it gives that showing and that angle grinder start moving. It's a
Okay.
battery powered angle grinder.
You agree with me that this angle grinder has something like a blade on it?
Yes.
Okay, was that powered on? Do you mean the blade started spinning while he was walking towards you?
Yes.
Did he say anything at that time?
No.
How did it make you?
How is he holding it when you say he powered it on towards you?
In my direction?
Just holding it straight out towards you?
Yes.
Is that also while he was walking towards you?
Yes.
How did that make you feel at that time?
Quite scared.
What did you do in response?
I quickly took a couple steps past that, ahead of that, so I shouldn't be directly within his reach.
At that point in time, did you believe that the defendant had the ability to hurt you, or that you were going to be hurt?
I wasn't sure. I definitely thought it was a possibility of being hurt. Yes.
While this was after these events transpired, that initial event, did a confrontation ensue?
The incident continued.
Okay, what happened next?
After I took a couple steps, he took a couple more steps with his angle grinder extended. At which point I took a couple more steps ahead of that.
What happened next? Defendant.
He put down his angle grinder and he went back into his house.
Did he come back out of his house after that?
Yes.
Okay. Were you still? Did you move at all after he left and came back?
I was pretty much in the same position.
Okay. What happened upon him coming back?
He charged out of his house. And I wasn't sure what he was holding. He was holding some object, so I thought he might come out the gun just with the speed and the vengeance that he came out. So I made a quick beeline and I ran down the street, the sidewalk.
Just to clarify and confirm, you believe at that point he had a gun in his possession?
He might have the the vengeance that he came out with. It looked like he was about to attack me, so I thought that there's got to be something which would probably be a little more efficient, I guess, than his angle grinder. So that's why I assumed it might have even been a gun.
Based upon your wording, I'm assuming that you still thought threatened at this point.
Yes,
What happened upon him coming back up?
I turned around and I saw that he was actually holding a camera.
Okay. Did the defendant continue to? Did the defendant make any statements at that time towards you?
I believe his statement was that he has it on camera, and he went on a long dialogue about the fact that I'm disturbing him and what right do I have to be on the sidewalk and so on.
What kind of clothing were you wearing at that time?
Exactly like this.
Okay, so a black suit jacket, black shirt, no tie, black pants. Were you wearing a yarmulke at that time too?
Yes,
Is that traditional religious garb for your religion?
yes,
What is your religion?
Jewish.
Okay. Are you Hasidic?
No,
Did he make any comments that were offensive to you based upon your religion?
in the ensuing conversation, yes.
What happened?
I walked back towards him and I told him that I was, I was not very comfortable with him videoing me, and I asked him why he was videoing me, and he continued videoing me. And this conversation ensued for the next couple of minutes. I asked him if he could step aside. I would like to walk back on the sidewalk the other way, and he vehemently refused. And that's how our conversation went back and forth. That he's going to have me arrested for what I'm doing, for disturbing, for so on. And I said, I just want to walk by. Do you mind please stepping aside? And together with that came the slangs and the slurs and the curses and everything else.
Do you remember exactly what he said?
No.
Do you remember what the nature of what he said was?
Yes.
What was the nature of the comments?
The nature of the comment, there's many comments. It was that I'm just bothering him. I am just being a nuisance. I'm not helping him out fix his sidewalk. I just want to, I think I can do whatever I want. I think, it's just, you can just do whatever you want to get away with it. And then there were a couple of other, comments, something about a white supremacist came in there, something about being Jewish.
He called you a white supremacist?
Yes.
Okay. That's something along those lines because you don't remember exactly.
Yes.
Do you remember anything he said about your religion?
No.
Was it based upon your memory? Well, you don't. Do you remember how you felt hearing these comments?
Yes.
Were those comments offensive towards your religion?
Yes.
During the course of this incident, did you later become aware that there was a video of this incident?
The video was right here taking video at the time.
Have you had the opportunity to review that video?
Yes.
Previous to you taking the stand?
Yes.
If I was to show you this video, would you be able to identify it?
Yes.
This is going to be people's proposed exhibit 2.
Okay. Can I have TV remote, please?
For a second.
Don't come back. Motherfucker. Don't come back. Do not.
Hi, I'm on New Jersey, 17, New Jersey, Southfield. Thank you. I called the police. The police. Hi. I'm having an issue over here with the neighbor on a block. I'm trying to walk down the sidewalk. They doesn't let any Jews walk down the sidewalk. They're screaming and cursing at us.
Okay, what's the address?
New Jersey.
Okay. That's the address where they live?
That's the address where they live.
Okay. And is it male, female, black, white?
Black males.
And what is it that they're doing?
They don't let anybody walk down the block in front of their house, walk down on the sidewalk. They scream and curse and block us on the sidewalk. And they hold like weapons up to us, like chainsaws and things like that, but it's just happening now. And I was wondering if somebody could come out.
Get the fuck away from my house.
Yeah. My name is Ezra, EZRA. Is it possible to come out because they're really taunting us and really acting aggressively at us?
I would recommend that you stay away from them until the officers get there. What's your phone number? And where are you going to be waiting to speak with officers?
On the block of New Jersey, just a few houses away. We'll see you when you come.
Okay. All right, we'll have somebody head over there as soon as we can. Just keep it out for the officer.
Okay, thanks so much.
All right, bye-bye.
Bye.
So can I help you? If you don't get away from my house, I'm calling the police. I got you on video. You're threatening my life.
Which way did it break? That is asking, I'll be done recording. I'd like to see it. Sir? Why are you recording it? Something's bothering you? Something that's annoying you? Explain yourself? Can I help you? Nothing likes to be sound like from the outside. Excuse me? Like that around? Can I reply, sir?
Yeah, I am. You're coming attacking my house.
I'm not.
Yes, you are. Keep walking up and back in front of my house. Well, you keep saying you want to come back and forth in front of my house. You just sat on camera.
I just want to walk back. I can shoot you back. Not having anything.
You are collecting. There's no reason for you to be here.
It's not inside.
You have no reason to be here.
You explain.
You prevent me from continuing my work at my home. You are the cause of disruption and confrontation.
Yeah. Since when I'm inside the station, stop you. It's not through the sidewalk, but the public walk on. Last time I checked.
Last time you checked, you walked up on me while I'm working on the sidewalk.
Okay, so I can call the police right now?
Hey, call the police.
The police are coming.
What?
What do you mean walk by? You just came up on my property. Well, I'm doing work. Call the police. You keep saying you don't call the police. Call the police. Call the police. You said you don't call the police. Call the police. Call the police. You don't want all big and bad. You want to be super hunky. Call the police. Call the police. This is not about what you want. You attacking me in my...
Video doesn't matter. 46 mark. Sir, can you agree with me? That you better call you a super
Now what?
super honky.
Super hockey.
A honky.
Super hockey?
That's what he specifically said.
Okay.
We playing the video at 7:46.
Call the police. Call the police. Call the police. Call the police. So you refuse to call the police and speak that you know you're committing crimes.
It's fine.
You are, okay, call the police then. You'll find out. Call the police. You want to find out? Call the police. Call the police. You'll find out what crime you committed.
What's the crime?
Call the police. You'll find out. So you will sit here and cause a confrontation in my house, disrupting my peace. All right? Call the police. Call the police.
Step aside.
Who the hell are you to tell me what to do at my house?
Down the side.
No, you
I was looking for Southfield, please.
I'm working on the sidewalk. You trying to disrupt my house, cause a confrontation, and disrupt my work. That's the only reason why you came over here. To attack me at my home. You lying scumbag. Yeah.
I called before about an emergency, and I can't give the wrong number.
087 video.
Yeah.
Let me just call your bunch one.
Yeah.
Did you say quite huge?
It was for New Jersey, so it's New Jersey? Yes.
I got it all on camera.
Thank you.
Thanks, man. I put down the side.
You're not trying to watch that time. You're trying to attack me at my home. And I got it on video shit.
Yeah. 17.
17021 New Jersey. I don't know who this guy is. I ain't never seen him before in my life. You're not trying to watch this out. You're trying to upset me and cause a disruption at my house. That's what you're trying to do.
Okay, do you know how long you're going to be here? Thank you. So we'll be right over. That's
Go fuck yourself.
nice.
Oh, okay, you don't hurt me. Okay. Then go away. You're a dangerous and persistent threat to my safety. At my home.
What am I doing?
Because you keep attacking me. You're disrupting me from my work. You're disrupting me at my home. You're causing a disturbance of the peace.
Alright, wait.
Oh, so you think it's all about what you want in my house? That's what you say. This ain't your property. I'm the one working on it. This is my property, and I'm working on it, and you up here gonna attack me at my house.
I'm not attacking you.
You are attacking me, because you won't go away. That's an attack.
That's not your fight.
You guys do this shit.
Daddy just called you.
I didn't get it.
Following the video theft. The 10.6
On it, and you up here gonna attack me at my house.
I'm not attacking you.
You are attacking me, because you won't go away. That's an attack.
That's not your fight.
You guys do this shit all the time.
That's the word type.
Yes, yes.
Play again. 50 seconds.
This time I got a camera.
That's wonderful.
Yeah, I know. You think that there ain't gonna be no consequences for the honkies. You think that you can just commit any crime you please and you ain't gonna be punished at all.
Please.
But I got you on camera this time.
Okay. I think
Yeah, I know. You keep running off at the mouth. Yeah, I know.
I don't know why I'm getting attacked.
No, you're the one attacking me. Yeah, you always play the victim. You come over to somebody's house, uninvited, unwanted, and start harassing the homeowner while they're trying to do some work.
You're the one.
Yeah, I'm gonna testify against you. If the city of South don't want a whole lot, man, this is crazy. A whole lot more problems. I'm gonna testify against you. Disturbing the peace.
Please.
Disrupting the homeowner.
Please. I don't know what.
I don't even understand why you're here other than to cause problems. Why are you even here?
Trying to walk.
What are you even doing here other than to disrupt the neighborhood? Everything was peaceful till you came around to start trouble.
I think I was taking a nice walk. Is that what happened?
Come up on me on my back while I'm working on the concrete.
I was coming up and I was
Yes, you did. You came all up on me. I'm up here trying to grind the concrete down to get it smooth, and then you come right up on me on my back.
I don't think
You could at least walk down across the street. Or maybe trying to maintain and improve the community, and you up here causing all these problems. I can't even continue my work because of you.
Please, go ahead. Go ahead.
When they going, who the hell are you to tell me what to do at my house?
I'm telling you, you can just continue doing what you're doing. I don't think it's gonna bother you. No one's trying to stop.
You won't bother. You up here arguing with me for at least 5 minutes. How about you won't bother me, lying piece of trash? I got you on camera. It's crazy how you do this stuff in my neighborhood. Lying like crazy. Man, this is why.
Please, I would love you to share that
You
with
say, please. All you got to do is just leave.
I want that to come
So you
down.
don't want to leave. You're doing what you want to do. You want to cause a disruption. You want to cause a disturbance. That's what you want to do.
I don't think this is wrong.
I got all this equipment out here. I got all this safety gear on.
The video, I think, 15 minutes or 7 seconds. But you take a seat, actually. Back in the legislature. So you agreed during the course of the confrontation, he made racial remarks towards you.
Yes,
That made you feel threatened?
yes.
I don't have any further questions at this time.
Cross examination.
There you go.
Good morning. Is it, how do you pronounce your name, sir?
Three Shabbos.
Chavez? Okay, Mr. Chavez, I had a few questions for you regarding that incident. So, when the prosecutor was asking you how the interaction started between you and Mr. Rhodes, you indicated, do you remember just testifying at the beginning that my client was walking on the sidewalk and you crossed over on the sidewalk? Do you remember saying that?
No,
You don't remember saying that? Okay. So when you arrived, you were walking on Pierce initially, you remember?
correct.
Okay. And then is Pierce and New Jersey, are they an intersection there?
Yes,
Okay. So you were walking in one direction on Pierce. Were you going south, do you remember?
my directions are not well. I was walking towards Mount Vernon.
Towards Mount Vernon. You made a right on New Jersey, is that correct?
Correct.
Okay, now, the person who starts videoing first was not Mr. Rhodes, but it was your friend in the vehicle who was following you, isn't that correct?
Correct.
Okay, so you guys staged, would you agree, you guys staged this interaction to annoy or harass Mr. Rhodes or to get some sort of reaction from him, isn't that fair to say? Okay, then why would you be crossing this house? You've never met Mr. Rhodes before, is that true?
Correct.
Okay, you never had any interaction with him before, is that
Correct.
true? But you decided to come cross his house and videotape something that you feel is going to occur. Is that what you were doing here?
Incorrect.
Okay. So you normally just cross every street in Southfield when you're walking, videotaping. Is that what you do?
I didn't take the video.
Okay. But you asked someone to take the video.
I should not ask anyone to take the video.
Okay. So the gentleman taking the video randomly takes, you don't know who that person was?
I know him well.
Okay.
And does he typically take video of you crossing the street?
He knows Mr. Rhodes quite well.
Okay, but does he know you?
He knows us, the digital media. Yes, he knows me.
Right, okay, but you don't know Mr. Rhodes, is that correct?
Correct.
Okay. So you and that individual were sort of working in concert, is that true?
No.
Okay. All right. Now, initially, when you crossed New Jersey, Mr. Rhodes had ear coverings on, isn't that correct?
Correct.
He was down on the floor with this grinder, is that correct?
Correct.
He was using the grinder on his sidewalk, isn't that correct?
Correct.
Okay. You came up from behind him and startled him, isn't that correct?
Objection. You can't know how the defendant was feeling.
I'm asking.
How would you know that?
I guess he could
By his
try
by his-
by whatever the interaction was or what he saw. He might know. So I guess I'll let him answer.
Is it possible that you may have started? You know.
He noticed me after I passed him.
Okay. So at the time that you passed him, he didn't notice you. He just noticed you after you passed him. Is that correct?
Correct.
Because he was busy grinding his sidewalk.
Correct.
Okay. Now, at that point is when he gets up. He's irate that you just did that you came up on him right from behind. Isn't that correct?
I didn't come upon him. I did.
But okay. So you came up from behind him and crossed where he was working. Isn't that correct?
I walked nearby where he was working. Correct.
Okay. And then he got up and he approached you and he said, "Hey, why are you crossing? You see me working." Do you remember him saying something like that?
Yes.
In the video, right?
Yes.
Okay. So he was upset about it, correct? He appeared upset. Isn't that correct?
He definitely appeared upset.
Okay. Your Honor, I'll ask the prosecutor not to nod at the witness as the witness is testifying.
Okay.
Thank you. Judge, sir, when you passed him and he stood up, okay, you were several feet away from Mr. Rhodes. Isn't that correct?
Correct.
Okay. You guys weren't right up next to each other. Isn't that fair? There was some distance between.
Correct.
Okay. And there was one point where he turned on the grinder and then walked away. You recall that?
One thing.
Right. One point, right? Okay. Split second, turns on the grinder, and the grinder's, first of all, you saw a picture that's been a demonstrative picture of a grinder that you said looked like the grinder. Is that correct? Correct one? Okay. And that grinder, have you seen an angle grinder before? Sure. Okay. You know it has a rotating blade at the bottom?
Yes.
Okay. When he took that grinder and turned on momentarily there, he didn't point it directly at you like this, did he? Okay. So you're saying in that video, he took up the grinder with the blade facing you and pointed it at you directly at you. Is that what I'm saying?
Yes.
Okay. So if the video shows that he had it sort of at an angle, but pointing more downwards, you're saying the video is incorrect. Is that what you're saying?
No. Pull it towards me.
Okay. Right after that occurred, he ran into the house. Is that correct?
Correct.
You didn't leave the scene, did you?
No.
Okay, you decided to stick around. Is that correct?
Correct.
Okay. You weren't afraid enough to leave at that point, were you?
Trying to see what's going on.
Oh, so a person comes at you with a grinder about what you believe being assaulted with a grinder, and you feel that you should stick around?
Objection, Your Honor. That's argument.
So let me rephrase that.
Yeah, rewrite it.
So after Mr. Rose did that, and you stated in fear for your life, you didn't run away, did you?
He walked the other direction. I'm quite a distance from him.
Okay. Did you run away?
Why would I run away?
Because
He's in his house.
I know, I'm asking a question. When Mr. Rhodes, when he turned that grinder in your direction, were you afraid?
I was afraid that it was going to continue till he asked me. Correct.
When you went into the house, you didn't leave that property, did you?
No.
Okay. You decided to stick around?
Yeah.
Okay. When he came out, he had a phone in his hand, correct?
It was a camera, actually.
It was a camera. So it was a camera, is that correct?
Correct.
He started videotaping you, is that correct?
Correct.
At multiple points, he asked you to call the police, isn't that correct?
Correct.
Okay. He starts making statements about, why are you coming up on me? Why are you bothering me while I'm working? You see me working. You remember him saying things like
Yes.
that? He was upset about that, is that correct?
Correct.
Okay. Now, the volume here is a bit muffled, but the prosecutor asked you each time, whether you heard him say "honky." You remember that?
Yeah.
You know what honky means? You have no idea what it means?
No.
When the defendant, there was a point in the video, there was one instance in the video where you indicate you heard him say white Jew. Is that what you heard on that video? Okay. He didn't say white honky?
No.
When he was repeatedly saying that you are on his property, why are you coming on his property? Why couldn't you go around while he was working? You recall him saying that?
Yes.
Okay. And he believed that you were on his property. Is that correct?
Correct.
At any time, did you make any effort to call the police?
Yes.
You picked up the phone yourself and could call the police?
Yes.
Okay. Once you crossed the sidewalk in this interaction, you were going in the opposite direction from his house. Isn't that correct?
Correct.
Why didn't you proceed on your way at that point?
Because once he, what I call assaulted me, I was very irritated.
Okay. So you were irritated but not afraid.
I was afraid enough to keep a distance. Yes.
And at the entire time you guys were at a fair distance. Is that correct?
Some parts more, some parts less.
Okay. Did the individual who you know who was videotaping this entire incident, did that individual ever come out of the vehicle?
After the police came, he came out of the vehicle.
Okay. While the police were there, did he attempt to assist you in any way?
No.
Okay. Do you remember him? You watched the video. Were you being directed to cross back into Mr. Rhodes' path?
No.
Okay. You don't recall hearing that on the video where the individual, your friend, taking the video, is telling you to just cross back. You don't remember hearing that?
After I was riding that direction, he's edging me to continue to go. Correct. Now I take the turn around.
Okay, to continue going past Mr. Rose's house, right?
Correct.
Not to continue on your way, you were already heading in the opposite direction. Isn't that correct?
At that point where my friend told me to continue, I was already having a dialogue with Mr. Rhodes that I would like to continue.
Okay. So you were being directed by your friend what to do. Is that correct?
Incorrect.
Okay. Now, you did hear him say that you heard your friend continue to reference on the 911 call that they are blocking out. They are doing this. Do you recall that?
Yes.
Okay. Now, there was only one person there. Is that correct?
Correct.
So he wasn't saying he was saying they, right?
Yes.
Okay. Do you know if your friend was engaged in any sort of ethnic slur, they meaning blacks?
I do not think so. You could ask him yourself.
Okay. But he wasn't saying he, and there was only one person there, and that was Mr. Rhodes. Is that correct?
Correct.
Okay.
Okay. Any follow-up question?
Sorry, Your Honor.
Sir, can we walk up here to the front, to the chair, where you sit down, and get shots, and raise your right hand?
Sir, raise your hand, please. You solemnly swear or affirm the testimony you're about to give the truth, whole truth, and nothing but the truth.
Yes.
Sir, will you please state and spell your name?
First name is Ezra, Ezra. Last name Romanowski, ROWSKY.
Sir, do you remember where you were at on May 18, 2025, around 2:30 p.m.?
Yes,
Were you in the area of New Jersey Street,
yes,
city of Southfield,
yes,
county of Oakland?
Yes,
What were you doing in that area?
I live right around there.
You live in that area?
Yes.
Okay. Do you know a person by the last name of Shabazz?
Dollars.
Chavez? Okay.
Yes.
And is he your friend?
Yes.
That's a individual who just previously testified for that.
Yes.
Okay. Were you two planning to meet in that area? Did you know that he was going to be in that area prior to you being in that area?
I saw him walking in the area. I did see him walking in the area. He was passing by my house, and I saw him turn about to be going down that block in New Jersey. So I figured I'd pull out my video camera to see what goes on because I know that the individual, the individual defendant has harassed many people in the area, and I saw him about to walk down the block, so I figured it would be a good time to video him.
Was this pre-planned or was this completely by chance?
Well, he was walking down there. I had a video camera with me, so even before this story actually happened, I was already videoing him because I thought that there was potential that something could happen. I did see the defendant outside of his home, and I don't know that my friend knew that. I don't think my friend knew anything about it, and I knew that he was outside his home. I don't think my friend knew anything about it, but I knew as somebody that lives right over there. My friend doesn't live right there. I live right there, so I knew this continuously happens to many people. It has happened to my children, so I thought it would be a good time to video him even before he got to that house. I pulled out the video camera and started videoing him because I knew there's potential for something to happen in there.
Did you tell your friend that you were videotaping before you pulled out your camera?
I don't recall if that was something that we.
Okay. Have you ever? Do you see the person that you know as Toby Rhodes present in the photo?
That is, yes.
Okay. Will you please point out? You believe or you know?
That is, yes.
Okay. Will you please point out and identify our article of clothing he's wearing?
Then or now?
What color shirt is he wearing?
Right now, blue.
Okay. You're gonna make the record reflect the witness to properly identify the defendant.
So ordered.
Thank you. You said you've had experiences in the past with Mr. Rhodes. What do those consist of?
So all the neighbors in the neighborhood, we know ones that live right around and know that we just try to stay away from that home because if we go past that house, he completely harasses us. We've been traumatized in the past. The first time we made a mistake to go past that house, we've been traumatized and really been harassed very strongly. He doesn't differentiate between children, women, male adults. All of them are harassed. My children come home crying. So we know not to pass by it, but there's always an unsuspecting person that lives a little further away that will make the mistake of walking past his home. It's always the Jewish people that he's harassing. And my friend made that mistake that day. He doesn't live right there, so he didn't know which home exactly. He didn't know which home. That there's a home right there that somebody could come out and harass, and he got harassed. And I had a video camera at that time, so I was able to video the whole thing.
Yeah, I'm going to approach the witness.
Yeah.
I'm going to show you what's on my computer screen. Is this the first scene of that video that you took from your vehicle?
Yeah.
Okay. This has previously been admitted as People's Exhibit 2. You were present for the complete course of that confrontation, correct?
Right.
And you actually called 911?
Yes.
Okay. While you were filming that confrontation, because the audio and the video is a little muffled, did you hear the defendant make any statements that were racial or derogatory in nature?
Yes.
And do you remember what those statements were?
He spoke about white supremacy. He spoke about, which meaning to say he's like accusing us of white supremacy.
Yeah, I'll object to what he thinks he was saying. The question is, what did he hear him say? And this witness is going way off. And
Okay, well, sustain. Answer the question. What did he hear?
What did you hear him say?
Hear him say that's white supremacy.
Did you hear him use the term honky?
Yes, I don't know what that means.
You don't know what honky means. Did you hear him use the term hike?
He did not.
You did not? You're positive you did it and you don't remember?
I did not hear that. Did not.
Did you hear him make any other statements?
Trying to think back, it's a long time ago that I hear another statements. Said, you don't pay your property taxes. You have no right to be here. Seem to be saying that, like, Jews, you don't pay your property taxes.
again, I'll object to what he thinks he was meant by it.
Sustain. Just what he said.
Yeah. Well, he's not testifying as to what he thinks he meant by it. He's testifying as to what it made him feel and believe that he was referring to.
I would still just all he can testify to is what is being said.
Well, the question was, what did he say? And he's interjecting what his opinion is as to what he thought he meant. I don't think he can do that.
What did you take those statements as meaning?
Well, it's the same question.
Well, that's personal to him and what he
Well, what he thought, not what
thought,
not what the defendant meant.
was thinking.
Right. Yeah.
So may you answer that question?
Yes, go ahead.
I thought he was trying to say that Jews have no business being around it. That's what I took it to mean. Now, if I say some more exact quotes of his,
Yes.
he said, you have no business being here. I'm pretty sure he used those words. He said, I don't know you. You don't belong here. I mean, those are things that just are I'm allowed to say what those words mean. What it means is like, you're Jewish. You just can't be around this neighborhood. This is our neighborhood. You have no business being here. So it's very, very demeaning. And it's just not only him. We all get it.
Did the police arrive at one point?
Yes.
Did you turn that video previously known as People's Exhibit 2 over to the police?
Yeah.
I don't have any further questions at this time.
President.
Mr. Rokowski?
Yes.
How are you, sir? I just have a few questions. So, you said you know of Mr. Rhodes, correct?
Yes.
Okay, you know where he lives. You live close by. Is that it?
Yes.
You live close by him.
Yes.
How many houses down?
It's not on the same block, but it's about 5 houses away, 6 houses away.
5 or 6 houses away. Are you on New Jersey Street as well? No. Okay. Well, what street do you live on?
Pierce?
On Pierce. The gentleman, Mr. Shabazz, is it Shabazz?
Yeah.
Okay. You know him?
Yes.
Is he a friend of yours?
Yes.
Okay. And when you saw him, you immediately said, I'm going to start taking video of this, right? Is that a yes?
Yes.
Okay. Initially, do you remember Mr. Shabazz? He was on Pierce, and then he made a right onto New Jersey Street. Is that correct?
Yes.
Okay. And then you actually started taking the video when he was on Pierce. Is that correct?
Yes.
Okay. He hadn't even crossed. Oh, is that correct?
Mm-hmm.
How did you know he was going to cross New Jersey?
I thought that it's just very probable. Just a normal, take his beautiful block, New Jersey. And I saw him walking down there, and I thought it would just be very proud like he was, going on New Jersey.
Okay.
It's very common walking that people think.
Okay. And so then you start videoing while he's on Pierce, correct?
Yes.
Okay. From your vehicle, is that correct?
Yep.
Okay. Do you recall Mr. Rhodes down on the ground grinding the sidewalk?
Yes.
Okay. He was busy, isn't that correct?
Yes.
He had some equipment there, isn't that correct?
Yes.
Okay. He had muffled ear protectors on, isn't that correct? Okay. And your friend, Mr. Shabazz, he crosses right behind him, isn't that correct?
Yes.
Okay. You don't know if that may have startled Mr. Rhodes, do you? You wouldn't know that, is that correct?
I know that. I do know. Yes, I wouldn't know.
Okay. So you know that when he passed by, he immediately got up and then he approached Mr. Shabazz and said, hey, why are you crossing behind me like that? You remember that?
Yes.
Okay. He was upset about that, isn't that correct? While he was working. Mr. Rhodes appeared irate or upset, isn't that correct?
Not about the fact that he was working.
But no, I'm asking you, did he appear irate or
Yes,
upset when he got up? Is that correct?
100%.
Okay. Now, at some point, you stated that Mr. Rhodes, as the interaction between him and your friend was occurring, that he was saying things like, you don't pay property taxes. Do you recall that?
Mm-hmm.
Okay. Is that a yes?
Yeah.
Okay. You have no business being here. Is that correct?
Yes.
Okay. I don't know you. You don't belong here. Isn't that correct?
Yeah.
Okay. You don't know if he was talking about, you don't pay property taxes at my house. I'm doing the work on the house. Do you know if that's what he meant?
It's possible.
Okay. Do you know if it's possible he says, you don't have no business here on my property? Do you know if that's what he meant?
Was he on his property?
I'm asking. In his mind, you can't read his mind.
I'm going to object to this point, Your Honor.
What's the objection?
Well, it's along the lines of speculation. I asked him how he.
No, it's cross-examination.
Okay.
That's fair. Go ahead.
Phrased it just so. So he's crossing
past Mr. Rhodes's property, is that correct?
No, he's on the side, public sidewalk.
I understand. He's on a public side, but crossing, he's on a public side in front of Mr. Rhodes' property. Is that a fair statement?
Yes.
Okay. So if Mr. Rhodes said, you don't have no business being here, he could have meant, you don't have no business near my property. Is that a fair statement?
Yes.
Okay. He didn't say you don't have no business being in Southfield, did he?
No, but
No, I'm asking you.
no, he didn't say that.
He didn't say you don't have no business being on New Jersey Street, did he?
He had to say he had no business being here.
Oh,
It's just on this public place on New Jersey Street.
I'm asking you. Did he say you don't have no business being on New Jersey Street? Did he say that?
No, but that was the context. That's what he was trying to say.
Did he say that? Is the
He
question.
did say that. Oh, for Paul said that's what he was conveying.
Your Honor, ask and answer. Did he say that? Did he say?
Did he say New Jersey? He did not say the words New Jersey.
Thank you. Okay. He said to your friend, I don't know you. Is that correct?
Yes.
Did he know your friend?
No, he did not.
That's a true statement, isn't it?
100%.
Okay. He said you don't belong. Is that correct?
Yes.
Is that correct? Okay. You don't know if, again, you meant you don't belong here on my property. Is that correct?
He did not mean.
Okay. But you don't know what he meant.
I know that he didn't mean that
Okay.
You know that, sir.
because he wasn't on his property.
Because you know what someone else meant is the question. Unless you're inside their head or they told you something that leads you to believe this is what they meant.
But
How
how
do you
can
just, sir, this is just simple yes and no questions. And my question to you is, how do you know what someone else meant unless they tell you what they meant?
Because from the context, you can understand what he's trying to say. And
What's the
the
context?
context is-
Because we don't deal in speculations in the law. We deal with the straight facts. So what is the context that we can draw what he meant here? Other than at this point, someone walking down the street, disturbing allegedly whatever he was doing there. That's the context I saw. I don't know anything else other than what I saw. And that's the context. How can you then read something else into what he meant? How can you know? That's my question. Because I sure don't know.
understand, Your Honor, but the question that he just posed to me was, did he mean that you don't belong on my property? And he wasn't on his property, so he couldn't amend it. You don't belong on his property.
Okay. Where he was and what he meant by what he said might be two different things, in my view. Because when someone says, on my property, a lot of people believe the sidewalk in front of their house is their property because they are, by law, charged with clearing it. No, that kind of thing in the winter. So some people believe that's their part of that sidewalk, just right there in front, is theirs. So how do we know what he meant when he said that? That's all I'm asking. And you seem to be real sure that you know what he meant. And I'm just asking, what are you basing that on?
So if he believe, if he's meaning to say you don't belong on the sidewalk, I totally agree with that. That was, he was trying to say you don't belong on the sidewalk. That is what he was trying to say. I agree with you. I do agree with that statement. He was trying to say you don't belong on the sidewalk. I was just saying he didn't mean to say you don't belong on my grass or you don't belong on my house. That's not what he was saying. He was saying you don't belong on the sidewalk. Now, a sidewalk is being public property. That to me tells me you don't belong in this area. You don't belong in this area.
But you don't know what he meant about what he thought was public property, do you?
You're saying maybe he thinks the sidewalks are.
People do. Unfortunately, whether or not that's accurate or not. But a lot of people may think that. So I'm just saying you're basing your opinion on what you think you know to be a public street. Therefore, he couldn't have meant that. But you're not him. So how do you know what he actually meant when he said that? Because he could have thought something a lot different than what you think.
That is possible.
Okay.
Thank you, Your Honor. I do want to get into some of the statements that you overheard Mr. Rhodes saying at the time that this was occurring. The prosecutor asked you, did you hear him say the supremacy, that you're a white supremacist to your friend? Do you remember that? Did you ever hear him say you're a white supremacist?
I didn't say you're white supremacy. I hear him say that's white supremacy.
Okay, that's white supremacy. Do you, you yourself, do you believe that white supremacy exists?
I do.
Okay. And have you had interactions with, let's say, neo-Nazis or something like that who are white supremacists?
I have the.
Okay. But do you believe there are individuals who are white supremacists? Okay. The prosecutor asked, did you hear him say hunk? You heard that?
I do.
Do you know what hunky means? You have no idea. But okay. The prosecutor asked you, did you hear him say, I think, hike? Did you ever hear him say that?
I didn't hear.
Okay, so you didn't hear it, correct? Okay. You're on ambulance.
Okay. Anything?
No, Your Honor.
Okay. Thank you, sir. You may step down.
This is my very last witness.
We have more.
Yes, you can tell me what. All right, I'll get. Officer Smith.
Okay. Last witness.
Officer Smith, if you're welcome to the witness stand. I'll see you before you sit down. Welcome, Judge Johnson. Raise your right hand.
Raise your hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth?
Yes.
Thank you. Have a seat.
Sir, will you please state and spell your name for the record?
Scott Smith, SCOTTSMITH.
Officer Smith, who is your employer?
City software.
What's your job title with the city of Southfield?
Specialist.
Specialist?
Yeah.
How long have you been a specialist for?
A couple months.
Do you work patrol as well?
Yes.
Were you on patrol? You're a police officer, correct?
Yes.
Were you on patrol working in your capacity as a police officer on May 18, 2025 around 2:30 p.m.?
Yes.
Did you receive a call for service at New Jersey Street?
Yes.
City of Southfield?
Yes.
What was the nature of the call?
It was a neighbor dispute.
What did you do upon getting there?
When I got there, we just made contact with both individuals involved.
Okay, do you see one of the individuals you made contact with personally in the courtroom?
Yes.
Can you please point and identify an article of clothing?
It's got on the brown jacket.
Your Honor, may the record reflect the proper identification of the.
So ordered.
Thank you. Did you make? Was any other officers with you at this time?
Yes.
Who was there?
Officer Gordon.
Okay. Who did you make contact with?
Mr. Chavez.
Okay. Were you in who did Officer Borvac make contact with?
Mr. Rhodes.
Were you in close proximity to see them?
Yes.
Okay. While in that close proximity, did you hear the defendant make any statements at that time?
Yes.
And what was he stating?
He's referring to Mr. Lorca and the other individuals and seeing as punkies, KKK, Nazis, and white supremacists.
He used the term Nazi, white supremacist, honky, and what was the last one?
Members of KKK, something along those lines.
Did you continue to have a conversation with the victims in this matter?
Yes.
Okay. Were you and also Borvac working a double unit at that point?
I believe we were in two separate cars.
Two separate cars. Did you transport the defendant at the end of this?
No.
Okay. Did you have any contact with the defendant during the course of this? Like direct contact, you spoke to him?
I believe I spoke with him momentarily.
Okay. Did he continue down this line of making statements as the ones you just stated while talking to Officer Borvac?
Yes.
When you made contact with him, did he continue to act as he was with Officer Borvac? Did his demeanor change?
No.
And I kept saying also Borvac, but is that last name is actually Borka before Borka. Okay, I was just saying his name. I don't have any further questions. Thank you. One thing.
Just briefly, Your Honor. Is it Officer Smith?
Yes, sir.
Okay, how are you, sir?
Good.
Good. So, this was on May 18th. Did you arrive at the scene first, or were you with Officer Aborted? Sorry. Aborted.
We arrived around the same time.
Around the same time? So you guys arrived two separate cars, right?
I believe so.
Okay. And did you witness any of the interaction at that time, or was it over by then?
It was over at that point.
Okay. And you said you're a specialist. What exactly does a specialist mean?
So evidence technician, but I'm still a police officer.
Okay. An evidence type?
Yeah.
Okay. Do you take photographs?
Not at the time. I wasn't having sick at that time.
On that time you weren't. Okay. Do you know if you knew that this interaction was being videoed?
Oh, I was made aware of this.
Did you see the video at all?
I did.
Okay. Were you the one who confiscated the video or took the video into evidence?
I don't believe so. I believe we provided a link for evidence.com.
Okay. Do you know if Mr. Rhodes was videoing any of the interaction on a camera?
I believe so.
You know if anyone sought to take that video in evidence? I don't recall. You indicated that you said you're the one who took Mr. Rhodes into custody?
I did not. I may have been there when he was arrested. I didn't transport him. That's what you're referring to.
Okay, so you didn't transport him in your vehicle, correct? No. Okay. But when he was talking, he was using terms honky, is that correct?
Yes.
Nazi, is that correct?
Yes.
White supremacist, is that correct?
Yes.
KKK, is that correct?
Yes.
Okay. Would you describe, let's say, you have no idea why he might be saying it, do you? Okay. Are you aware of have you had dealings with Mr. Rhodes before ever?
Yes.
Are you aware of any mental health issues that Mr. Rhodes may have?
Or
Have you ever had to arrest him before?
not that I recall.
Okay. Have there been between the complainant here is Mr. Shabazz. Do you remember the person who he had the altercation with?
Yes.
Okay. Had that individual ever called regarding Mr. Rhodes before?
Not that I know of.
Okay. Do you know who was taking the video?
Yes.
Okay. That was Mr. Ezra Rakowski. Are you okay?
Yes.
Okay. Has he ever called the police regarding Mr. Rhodes before?
Not that I know of.
I had nothing to do with it.
Anything?
No, yeah.
Okay, thanks.
People arrest.
Any witnesses?
Yeah, different class.
Okay.
People moved to bind the defendant over as charged in the complaint / general information in this matter.
Okay.
Yeah, argument for rebuttal.
Your Honor, defense is going to object to a bind over on this. So there are two charges that my client's been charged with. One being assault with a dangerous weapon, felonious assault, and the other being ethnic intimidation. Both are felonies. I want to address the felonious assault charge first.
Mm-hmm.
So regarding the felonious assault, the elements are, first of all, that the defendant assaulted Mr. Chavez or placed him in fear of imminent battery. This grinder. Okay.
Okay.
I think what the evidence showed, and we watched the video, that this was a momentary occurrence between Mr. Rhodes regarding at least the grinder. That if you look at the video, Mr. Rhodes was not within reach of the complainant here, Mr. Chavez. Okay. The witness testified that they always had several feet of space and distance between them. That the only incident we see is right at the very beginning when the witness passes by Mr. Rhodes as he's got his ear pieces on. He can't hear. He's got the grinder running. He's working on the sidewalk. He's busy doing that. He's got equipment out there. And here comes this gentleman almost, rushing past him, which clearly got Mr. Rhodes' attention and got him irate. The fact that someone would do that, knowing and seeing him visibly working, and there's an individual sitting in the car videoing the entire interaction, riling Mr. Rhodes up. clearly what was occurring here from Mr. Rhodes' point of view was that this was sort of a stage effort by these two individuals.
Well, how do we get there? We haven't heard from Mr. Rose about his point of view.
We see is Mr. Rhodes' reaction in that video.
Yeah, we did see that.
So he gets up, the grinder turns on the grinder. He never directs this grinder at this individual. He's got it down at the side and immediately turns it off and goes into the house.
Yeah, that was my question is, was it actually pointed at him? Because that's what the witness said.
But that's not what we saw, Judge. I mean, I watched the video in the hallway. I watched the video here. Okay. That grinder was not pointed at the witness. I mean, if you look at it, it's pointed sort of on the side like this. He turns it on for a second, turns it off, and goes into the house. Leaves the scene. He doesn't charge at Mr. Chavez. He doesn't make any other threatening gestures towards Mr. Chavez. He actually goes in and grabs a camera because he knows he's being videoed by a dude in the car, and he starts videoing this individual who's crossing in his path and won't leave him alone, and it's bothering him from his perspective. Clearly, in the video, he felt that this individual was bothering him.
Mm-hmm.
Now, whether that's rational or not, that's not for us to say. But clearly, by Mr. Rhodes' reaction here, that is what he felt was occurring. So there was no assault that was committed on Mr. Chavez. There was no threat of any immediate harm to Mr. Chavez. Mr. Chavez was not afraid. He testified. He was not afraid. He didn't leave the scene after this occurred. He didn't call the police immediately after this occurred. In fact, he came towards the house and sought to cross the path yet again. This is after supposedly being assaulted with a dangerous weapon. So there is no reasonable apprehension of any battery in this situation. The prosecutor has not met their burden on that element. And the court should dismiss the charge of assault with a dangerous weapon. There's no probable cause after that. If you take the charge of ethnic intimidation, okay. I mean, we listened to the video, and I'll tell you, I listened to it twice myself. I could not hear the word Jew or Jew said. I didn't hear it in that video. It was muffled. The witness thought that that's what he said. The witness indicated he doesn't know. One of the witnesses indicated if the word the kite was said, he doesn't.
And nobody even defined what that is.
Okay. No one knows what honky means.
And nobody defined that either.
Neither one of them knew what that means. If he said the word white supremacist, that's not an ethnic slur. White supremacist is a general term that the second witness indicated that he believes he knows what that is and it exists in the world, but it wasn't related to the gentleman's ethnicity. He's saying white supremacists. Okay, in Mr. Rhodes' mind, there's such thing as white supremacy, and that's what he believes. Okay, so the prosecutor did not, and there was no malicious intent to specifically harass this individual by calling him a white supremacist without anything more. Because what they would have to show is that in addition to that, that harassment was met by some act, some ability to act on that threat. Okay, that's what 17.34, the jury instruction for ethnic intimidation requires. And that didn't happen here again because their entire case hinges on that momentary action by Mr. Rhodes of sort of turning on that blade and then turning it off without pointing it at the complaining witness in any way. Mm. So there's not probable cause here that my client committed an act of ethnic intimidation on this individual. There is no probable cause that he committed assault on this individual. I think this is a very weak case. Does not meet even the level of probable cause. It is not a question of fact. We watched the video. The court is the judge of the fact, the evidence that we saw, and it doesn't meet that criteria. I asked the court to dismiss both these charges for lack of probable cause.
Let's start with the ethnic intimidation.
You want me to start with that? Then intimidation?
Sure.
Yeah, no, the court can take judicial notice of the dictionary definition of the word kike, which is a contemporary term towards the Jewish community. That's a very common term.
I don't even know how to spell it, let alone take the dictionary.
I was not aware that the court didn't know what that meant. I mean,
No one defined it. I don't know what it means. I don't even know. He said he heard it. I wasn't clear on what I heard even, but yeah, I can look it up. If this is what you want me to do.
I'll ask the court to take judicial notice of what the definition of a kike is. If the court is unaware, I can spell it for you if you
Okay.
want to look it up. K-I-K-E. And then we have the defendant doubling down once the police show up and start referring and continue down the line of stating white supremacy, honky.
What was white supremacy and ethnicity? I don't understand that.
It's just another racial term that's being used in conjunction with, you remember, the Nazi party, which would be offensive, obviously offensive to a member of the Jewish community.
It would be. I mean, see, this is what I don't like about this particular charge in this particular instance. Everybody is like jumping in and putting their spin on what they think the defendant was trying to say or do. I don't know anything about white supremacy being used and would be technically an issue as to the term, the Jewish community. Certainly nobody said they were offended by it. What they did say is they knew of it. The one witness said that, and he believes there are white supremacists out there. But, you have to show that the defendant said white supremacists because of their religion or gender or origin or color. I mean, rather than he just used it as a term.
Well,
because see, right here, I was expecting to hear a little bit something different than what I heard today. And it seemed like to me, and this is me, that the whole thing started, and I understand that the second witness, Mr. what was his name? Rakowski, feels in his mind that it's because he's Jewish and other Jewish people live in the neighborhood. But that didn't really specifically come out in this particular instance. He may have some reason to feel what he feels, but I got to look at what I'm looking at. And what I'm looking at now is a situation that seemingly started just because somebody walked down the street past Mr. Rhodes while he was doing some work with his earphones on with a machine. And I don't know what it was about, because I thought to myself, well, if this gentleman was scared, he sure had a chance to just walk on by. And he didn't. He stayed there and he sort of got into it with Mr. Rhodes. But Mr. Rhodes didn't say anything to him at first. He said he didn't say anything to Mr. Rhodes. So it didn't get started because of, quote, racial reasons or ethnic reasons. It seemed to get started because, and I watched the video again, because Mr. Rhodes was talking about, why are you walking past me like this? So it seemed to kind of get started because of the work he was doing, and maybe he did get startled. I'm not sure.
Well,
but then the only thing after that you're saying is making it, he did this out of race or ethnicity, is the fact that he called him, and he didn't even call him a white supremacist. The words that the witness said was, that's white supremacy. That's different than referring to somebody as a white supremacist due to the fact that they're racial or ethnic background or anything else. So it's almost like he said that's white supremacy in response to something that the gentleman said to him. So if that's what you're relying on, I don't see that as racial or ethnic intimidation.
Well,
So then the next thing you got is the words. Let's see, what do we have? We have a word cake. And I have to go back and listen to what he said and how he said it. And the word hockey, which don't know what that means.
what monkey?
Listen, I am not going to impute my personal knowledge into anything because it's not my job.
Well, you can.
So,
I mean, I think that's a common word and common sense tells you. Okay. All right. All right. Nonetheless,
so now, if somebody else said, "Hey, you know what? This is what this means," that might be different. But it's just a word thrown out there. And you wanted me to look at the word cake, and I'd have to look it up and then see, in what way that he used it. But you have to show that he didn't act or threaten him because, not like he could have done something and had nothing to do with the fact that he called him that was a white supremacist, or that is white supremacy. He could have done something and it had nothing to do with the fact that he sees him as a Jewish man. I'm not sure.
What I'm hearing the court saying, correct me if I'm wrong, we don't even get to the point of the words used because you don't believe the felony assault was committed because of that necessary.
You got to show that first, is what I'm getting at.
I understand.
Yeah, you got to show that the threat to do or he either caused physical harm or he threatened to cause physical harm. And he did it because they were Jewish. I don't see that in this low fact scenario here. Not saying that maybe he hadn't done it in the past. I don't know. But this low fact scenario is real limited. And yes, he used the word, this is white supremacy. And I think in response to something that he heard, he used the word kike. But when he got up, he was talking about the fact that the person walked past his house and he didn't know who he was. He was on his property and he seemed to be real upset about the fact that he walked by him while he's doing the work. That's what I kind of got out of it. And I'll look at it again.
Well,
so how do I connect it? Even if I were to say, okay, well, yeah, the word kike is some kind of ethnic slur. How do I connect the fact that he threatened him because he was a kike?
Well, the court would have to find that he had that subjective understanding in his mind upon making the determination come after him put the grinder. Moving on to the felonious assault. The clear reading of the video is completely contrary to what the counsel just said. I reviewed the video while the counsel was making his argument.
Okay.
The victim walked past him. He stands up, holds the grinder towards him, walks towards him, spins around for a second. I believe he looks at the direction of the camera, and then continues on the path and pulls the trigger. That's a deliberate move to try to threaten this person.
Okay.
And it's in the mind of a reasonable person at that time. With me holding up a grinder, then turning around and looking, and then continuing down this path, pulling the trigger, walking towards him. Would that make a reasonable person fear that they're about to be subjected to a battery?
Okay.
I believe there is probable cause for the felonious assault. I would still ask the court to bind the defendant over as charged, but
okay. Well, yeah. Mr. Messi, I heard your argument. I wasn't quite there on the felonious assault charge because it is a very low threshold burden to show probable cause that crime may have been committed and probable cause to believe that it was the one who committed it. And so I think it's up for reasonable interpretation from a jury as to why did he why did he jump up? Did he really mean to do that to frighten him? Because then he didn't just jump up, he turned it on and held it out a little bit. The witness says, I was afraid that something was going to happen. I wasn't sure. Now, was he? That's questionable as to how afraid was he? Because a jury could say, well, he wasn't really afraid because he didn't leave. He just kept on standing there and he waited for the guy to go in the house and come back with what he said he thought was a gun and saw it was a camera and came back and still wanted to argue. So those are good questions of fact for a trier of fact as to what was Mr. Rhodes's action? What did he mean when he turned this thing, got up, held his hand out towards him in some way and turned it on, even though he didn't lunge directly down at him? He did the act. And was that enough to put a reasonable person in fear that, well, maybe he would have lunged at me? That's what the witness said. And the elements that need to be shown are first that the defendant either attempted to commit a battery or did an act that would cause a reasonable person to fear or apprehend a battery. And so when you got a power tool in your hand and you turn it on and hold it out, that's a good question of fact as to what you meant. And is that an act that would cause a reasonable person to fear the battery? The second element is that he intended to either injure or to make the person fear an immediate battery. Well, I don't know if he intended to injure him because he sure didn't make a move towards him. But again, did he mean to reasonably make him fear a battery? Well, maybe so, because he turned it on and stretched his arm out for a minute. The third element is at the time the defendant had the ability to commit a battery or appeared to have the ability or thought he had the ability. Well, yes, it appeared that he did have that ability. And fourth, that the defendant committed an assault with a dangerous weapon. I don't think anybody's arguing that this, whatever the tool, power tool was, it was testified as to being by Mr. Chavez. Because I never heard of that. It said something about an angle grinder. Yeah. So I think that could be a tool for sure that could be used in a dangerous manner because it's electric or has a battery and has a rotating like saw grinder thing attached to it, as is shown in exhibit number 1. So all those elements are all that's needed to show for probable cause purposes. I think people met their burden. I'm dismissing count 2 with ethnic intimidation. I don't see that here. I don't see a threat to cause physical contact simply because of the person being a Jewish person. And even the testimony of the second witness, Mr. Rakowski, was all about him trying to put what he thought the defendant meant in his mind. But it wasn't clear by any of the set of circumstances that the defendant did this because this person was Jewish. The most I got was his referencing something about white supremacy. And if he did say the word kike, and if it does mean what the prosecutor is saying, it means something about being a Jewish or defamatory statement, you got to connect up the act to the fact. Now, he could be racist all he wants to be, but if he didn't do an act because of the person's race, then you don't really have the ethnic intimidation. And it appeared to me that all of whatever he did seemingly was born out of this other element of trying to be upset because the person walked near him while he was working. And the whole conversation appeared to be about that, although he did mention the word, said something about that sounds in white supremacy. And he mentioned the other word was hockey. But it's got to connect to that's the reason why he pulled this tool. And that I just didn't see that there. So for those reasons, I'm going to find, because the element has to show that the defendant did it because of the race. And I just don't see it under this particular set of facts. So count 2 is going to be dismissed. Count 1 is going to bind over as charged in the complaint. We'll continue the bind. Oh, here's your exhibit on the grinder.
In the Butler County District Court, entitled State of Kansas versus Quentin Lawrence Height. It's case number 2025 TR 1215 and 2025 CR 261. Jared Regier appears on behalf of the state of Kansas and the Butler County Attorney's Office. William Peterson as defense counsel. Quentin Height appears from the Butler County Detention Facility Zoom location. Court will review. This matter last came before the court on October 21, 2025. At that time, a hearing was conducted primarily on discovery issues. The court made certain orders of turnover of reports and materials. The court granted no relief otherwise on the subpoena quash order that the court had earlier made. Court then proceeded to take up a request by the defendant to continue the jury trial, and that was granted. The case was reset for jury at December 10, 9 o'clock a.m. with a pretrial conference established December 3 at 4 o'clock p.m. That time it was announced that the pretrial conference would also be in person. The court reaffirmed its bench warrant bond forfeiture no bond hold order due to the defendant's failure to appear previously. The defendant was placed in custody with a no bond hold. Court set a discovery compliance review hearing for today by Zoom, and court, of course, contemplated the defendant would participate from the county jail. Subsequent to that hearing, apparently Mr. Peterson has been retained to represent this defendant in both cases. Is that correct, Mr. Peterson?
Yes, it is, Your Honor.
All right. Is there any progress to announce regarding case disposition?
Yes, Your Honor. There has been in my short time on this matter. I've had a couple of discussions with Mr. Regier, including a phone conversation yesterday in which we talked about previous plea discussions, and that my client did inquire about diversion eligibility here. Mr. Regier referred me to their rules, which my reading, I don't think there's anything in there that precludes an offer of diversion if Mr. Height applies, which he would like to do. Also, Mr. Regier did send over an offer in regards to resolving this matter that my client and I have discussed briefly, and I believe that it also has, well, it's something we discussed as being able to, it's amenable to my client, I should say. But again, the diversion option is something that he would like to also look into. So at this point, Your Honor, we're prepared to let the court, set aside any future or any discussion on discovery compliance or any further discussion on the motion to quash, and even take the matter off the trial calendar if the court's inclined to do so, and allow my client to decide which of these two routes he'd like to go.
All right. As previously announced, Mr. Peterson, I do have a pretrial conference set December 3rd at 4 o'clock. I could convert that to Zoom, but the court wouldn't want this case or these cases to fall off the calendar. If the defense is specifically requesting I take it off the jury trial docket, I will, but I wouldn't want to leave the pretrial conference setting if you're available. Mr. Peterson, your availability by Zoom, December 3 at 4 o'clock?
Yes. And my hesitation, Your Honor, I was going to request that in person because Zoom is not our favorite thing to do. And what I mean by that is I'm in Topeka. Mr. Height is down there. We've got to travel to be in the same room anyway. And for other reasons, we prefer a in-person hearing, which...
Well, Mr. Peterson, I tried to do that as an accommodation to you.
I appreciate that.
If you want an in-person hearing, I think that's how it was originally set.
Yes.
And the court can maintain that as an in-person. All right. December 3, 4 o'clock. The court will essentially set it for a pretrial status hearing. And I can remove this case off of the jury trial calendar for the December 10th date at counsel's request. Is that what you're asking the court to do, Mr. Peterson, specifically?
Yes, Your Honor.
Very well. Court will make that order. All right. With our next court date set and the matters that have been announced, is there anything else that we need to address at this hearing, Mr. Peterson?
Your Honor, I did file a motion to set aside the forfeiture of the bond in both of these matters. And I
We may proceed further on that motion if you desire, Mr. Peterson.
Yes, I would like to be heard on that. As I stated in the motion, Your Honor, Mr. Height is asking the court to set those forfeitures aside. A couple things I would just add from the motion, and I think it did include Mr. Height doesn't have a lot of experience with the criminal justice system, and he did, as you're aware now, heed the warnings of the court to hire counsel, get some assistance. He's done that, and I think moreover spent the last couple of weeks in a lot of self-reflection and thought about how to handle these types of situations and how to handle this current situation. And he is, like I said, taking steps to rectify this and make sure he's never put himself in this type of position again. I think that the court's forfeiture of the bond and him sitting in jail has shown Mr. Height the ways of, it's important to always adhere to the court's rules, adhere to procedure, and is asking the court to allow him an opportunity to show that he can do that. We have an in-person setting, engage in discussions. He's taken steps to rectify, what the registration offenses, as I put in the motion, prior to being placed in custody. And again, back to his very limited contact with the court system and law enforcement previous to these two cases, I think Mr. Height is in a position where searching for a phrase, but learned his lesson is this kind of one that jumps out at me at this point. So he is asking the court to, in the interest of justice and these, they're misdemeanors. He's aware of, what he's accused with and the very serious nature of interference with law enforcement. And, but he'd like an opportunity to show the court that he can do this without, move forward without being in custody and resolve these matters.
Very well, Mr. Peterson. I am familiar with the contents of your motion to set aside bond forfeiture previously filed. Mr. Gear, on behalf of your office, what is your position regarding this request?
Your Honor, with all due respect to the court and counsel, the state's position is the court's prior order should be maintained. These are two cases where the court found the defendant disregarded the orders of the court and failed to appear for a critical in-person motions hearing on October 2nd, which the state does consider troubling, especially since the defendant filed multiple demands for in-person hearings in both cases in July. It would appear that between the October 2nd and the October 21st setting, rather than submitting himself to the authority of law enforcement, the defendant filed 3 separate motions in each case, 6 total in the aggregate. And it is the state's understanding that it was only through extraordinary measures taken by third parties that the defendant successfully appeared in court during the October 21st hearing. The state further understands that this court heard argument on the issue of bond at the October 21st hearing, and it would appear that the arguments raised by counsel for the defense in the motion are largely similar, if not identical, to the same arguments raised at that setting. And at that setting, the court did find that a cash or professional surety bond was not appropriate in either of these cases. Based on the procedural history of these cases, it does appear that this is a defendant who's able to file a number of motions and subpoenas and to retain private counsel, but not to appear in court when ordered. And the state is not aware of any new information which might reasonably justify the modification of the court's prior orders. So the state's position is the court's prior order should be maintained.
Mr. Gary, you make some good points and you articulate your position well. However, I think there has been one material change in the status of this case, which this court should take into account, and that is counsel's involvement, which was not present previously, which in the view of the court would help to cut down any of the what the court would deem communication issues that we've experienced in the past regarding Mr. Hite and his cases. But before the court makes a ruling in this case, Mr. Peterson, the court has several conditions it would impose. Number one, I want a statement on the record right now from Mr. Hite as to where he will be residing. And I don't want a P.O. box. I want an actual street address where he is representing to this court is his residential address.
The address that is on my driver's license is current. I do have a question. This is being...
All right, Mr. Hite, let me back up a minute. I hope you're just not playing word games. I want to know where you're actually going to be staying. I don't care what's on your driver's license. I want to know where you're actually going to be sleeping at night, where you're going to reside. Is that the actual residence where you live?
Yes, it is.
All right. Fair enough. You've been asked a question by the court. You have one for the court, Mr. Hite. Be careful.
I was just going to raise a concern about the live streaming and of me putting my address out onto the internet. That was all. I
understand your concern, Mr. Hite. I trust anyone who is familiar with the internet could probably locate that address if they wanted. All right, the second requirement, Mr. Peterson, and it's a simple one, and that is this court would require as a condition of bond or your agreement, Mr. Peterson, as counsel in the case, to confirm in writing after each court appearance the date, time, and location of Mr. Hite's next appearance and confirm that with your client in writing. I would need that commitment from you.
Absolutely, Your Honor. Standard of practice.
Indeed. Indeed, it should be. You'd be surprised, however, Mr. Peterson, how many attorneys these days do not do that.
I understand.
Thank you for that commitment, counsel. I'm satisfied. I think that some of the problems we've had in the past have been adequately addressed by what we've talked about today. This court at this time will, at this time, reinstate the cash bond in each of these two cases, set aside any particular order of forfeiture that might lead to judgment on bond. You're back on bond, cash bond in both cases, Mr. Hite. I will order your immediate release on these two cases. If for some reason you have other holds that we haven't discussed here, I'm not releasing you from those. But in regards to the two cases currently before the court, I'm going to reinstate bonds on both with the conditions and matters that we've discussed here in this hearing. Any questions about that, Mr. Hite?
Not at this time.
All right. We have another court date set, December 3 at 4 o'clock. The court's ordering Mr. Hite, as a condition of bond, of course, to appear at that time, courtroom B, Butler County Judicial Center, for further proceedings in the case, which will be conducted as an in-person proceeding. All right, Mr. Peterson, with those rulings made, which I will expect you to promptly document through order, is there anything else from your perspective that we need to address at this time?
No, Your Honor, that has covered everything I have.
I think there's been certainly some discussion here about some matters being resolved by more or less agreement. I would hope that that will be moved on quickly so that there can be an appropriate announcement made on December 3, at least regarding the progress of those matters.
Absolutely.
All right. Thank you, Mr. Peterson. Mr. Regier, anything further that we need to address currently?
Not from the state's perspective, Your Honor.
Very well. I trust that there is someone from the detention facility who is hearing the court's orders and the order of release.
Yes, Your Honor.
All right. Essentially, it's reinstating of the prior cash bonds in the matter and releasing the no bond hold that was previously put on him by this court. All right. Thank you. I appreciate your involvement as well. If there's nothing further, then the Quentin Lawrence Height matter, or both cases, will be in recess at this time, and this meeting may be ended for all.
Will be on the record on Rihanna Johnson, BU 2025 TR 1899, State of Kansas versus Rihanna Ray Johnson, Jared Regier for the state. Rihanna Ray Johnson, that's you appearing in person in pro se.
Yes, ma'am.
Ms. Johnson, you're charged with count 1, driving while suspended, a B misdemeanor. You're charged with driving without proof of insurance, a B misdemeanor. Well, may I correct that on number 2, you're charged with driving without insurance after a prior conviction for driving without insurance in 3 years. That prior elevates it to an A misdemeanor. You could be looking at a minimum fine of $800 up to $1,000, and you could be looking at up to a year in the county jail. How do you wish to proceed on the issue of an attorney? Do you wish to have an attorney or?
Yes, I would like to get a court-appointed attorney.
All right. Are you employed at this time?
My what?
Are you employed? Do you have a job?
Yes, I do.
Where do you work?
Premium Retail Services.
What do you get paid per month?
It varies, but I average probably like 30 hours, about 25 to 30 hours.
What do you make per month?
I make $13.50. Oh, I mean $13.50 an hour.
You make $13.50 an hour at 30 hours a week. Is that what you just said?
Yeah.
But you don't know how much you make per month.
Well, it varies so much, but I average it out to be about 30. So
Are you saying about $405 a month? Does that sound right?
I'd say it's probably a little more, like about 600.
All right. And what do you pay for? Are you married or single?
Single.
Do you pay rent?
Well, that wouldn't be per month. That would be that's a week. Like so that would be
about $2,400 roughly.
Yeah.
You're saying $600 a month?
No, not a month. No. That's why I was like, wait a minute. Yes, I pay rent and electricity.
How much per month? Tell me the amount.
600. 600 in rent. I don't know on the other because I had just moved in, so I'm guessing maybe like 200 in electric and 100 in gas, maybe.
Any other expenses?
I have a cell phone. My child support.
Well, you have to tell me the amounts.
My cell phone is like $240 because I pay for my kids' phones.
Okay,
and
but you don't have to. Hold on, you don't have to pay for your kids. How much is yours?
How much is mine? Mine is like 120, I believe, because I have internet with it.
Okay. And you said some other figure. What was it?
I have child support.
Do you pay that child support?
It is like $370 something a month.
Do you pay that or receive it?
No, I pay that.
But you're not sure exactly how much?
I think it's like $167 per check.
What else do you have, if anything? Car payments?
No car payments. Insurance, I don't have that yet because I'm not driving, but I have to get an SR22, so it'll be quite a bit. But I don't know what else you claim. I don't know.
But you don't know what your car insurance is going to be. You haven't talked to anybody about that?
Yeah, it's pretty high. It's going to be like $190 for liability on my car. And that's a month.
You said child support. How many children are you supporting?
3.
So your family of 4. All right, I'll find you qualify and appoint attorney Darren Patterson. Have you taken down his number yet?
No.
Darren Patterson, Darren Patterson. His number is 316-322-7700. Call him today. That's an order. Come back with him ready to go. And the next court date for Darren is when?
Your Honor, that is January 12th.
January 12th, 8 a.m. You have to be back.
I didn't catch that because somebody else was talking. What was that?
Well, it's January 12th, 8 a.m. You have to be back here by Zoom, ready to go with Mr. Patterson.
Okay.
And Your Honor,
Mr. Aguirre.
some new information has been brought to my attention recently regarding this matter. If I may request a brief 2-minute recess.
Granted.
Thank you, Your Honor.
Recess. You're welcome.
Thank you, Your Honor.
You're welcome. Back on the record in BU 2025 TR 1899, State of Kansas versus Rihanna Ray Johnson, all parties as before. Anything further, Mr. Aguirre?
Merely that the state wishes to be heard on the issue of bond at the appropriate time if the court is making such an order.
This is the appropriate time. Please proceed.
Your Honor, in addition to the 2 charges currently before the court, both of which the state considers considerable, especially in light of count 2 being charged as a Class A misdemeanor, the state is recommending a bond of at the very least $3,500. The state does not oppose the court ordering an OR bond, given that the defendant appears in the fashion that she does today. Besides the charges currently before the court, the state understands this is a defendant with at least 1 prior driver's license violation, a diversion for DUI, as well as at least 1 non-traffic felony conviction. Under those circumstances, the state does respectfully submit that $3,500 is appropriate.
I have a question.
Go ahead.
On that, the DUI, I haven't received a DUI. I don't believe like I've received one. When did they say I had a DUI on that?
I didn't hear a date or time. I can look and see what I have. The record you have that I see for Odyssey starts with speeding in 2004, and then it jumps up to 2000. Well, that's a different kind of matter. You have a 2013 criminal for damage to property, interference with Leo, law enforcement. But it looks like the conviction was for criminal threat.
Yeah, I knew that. That's been like 12 years ago. But I don't recall ever getting a DUI.
Well, I'm looking for that. In the meantime, Mr. Aguirre, what year do you show that for her benefit?
Your Honor, in response to the court's inquiry, it does appear to be somewhat dated. Nevertheless, given the nature of the offense, the state does consider it relevant for purposes of setting an appropriate bond in this matter.
And when was it dated, you said?
I don't see it on her Odyssey, so it may not have been in Kansas, but how long ago was that? You said somewhat.
Approximately 20 years by the state's understanding, Your Honor, per the court's inquiry.
20 years. 20 years. So I don't even recall ever getting one 20 years ago, but so you bring up something for 20 years ago?
Sure you can.
I mean, I don't recall ever getting a DUI 20 years ago.
Well, I don't see it on your record. I'm not going to consider it, but for all the other reasons stated, 3,500 OR sounds reasonable, and I am going to make that your bond.
And why is that? Just because I have.
Well, because you have a lengthy record, ma'am, from starting in 2004 up current, keeping it up till now. 2013. Do you want me to go into all of these? The criminal.
I mean, I don't have
criminal charges.
But that's been like 12 years ago and has nothing to do with my driving, like record.
Well, your record has something to do with your record.
That's one felony. That's all I have on that. Like, I mean, I'm not trying to argue with it, but I don't have a really extensive record except for a couple driving on suspendeds. Like, I mean, I really don't.
Well, I'm giving you an OR bond. That means you don't have to put the money up, and I'm not going to go there's not much less I can do on that. I could say, oh, well, 500 OR, and I'm not going to do that. You've got a long record here of different kinds of activities indicating to this court that you could be a flight risk. And so your bond is set at 3,500 OR. You may not like that. You may not approve of that. If you find yourself some kind of appeal, avenue, you can try that. But that's your record at this time. That's your charge at this time, and that's what you've also had a failure to appear in this case, Miss Knoxted. You failed to appear April 23rd. In this case.
This case, not this one because I just got this 2 months ago.
My apologies. I was looking at Knoxted's and you're Miss Johnson. Let me look at that again.
Okay, because I'm like, I'm not.
Okay, let me double check your screen. That makes a lot of difference. It actually makes it worse because now you've got driving while suspended. Okay, you are Rihanna Ray Johnson, correct?
Correct.
You have driving while suspended and driving without proof of liability insurance after a prior conviction of driving without insurance within the last 3 years. So you've got an A misdemeanor, a B misdemeanor.
Mm-hmm.
And you've had Mr. Patterson, but you apparently didn't go over and contact him like I told you to.
To who?
Darren Patterson. Are you saying
I haven't done it yet because you just now told me to today.
All right. All right.
I mean, I'm still in court, so I can't call while I'm in court, right?
Right. Now, Miss Johnson, you better calm down because you're not going to do yourself any favors here. But here's your record. Going back to your record, 2004, there's speeding.
Mm-hmm.
There's some children involved in some cases that I won't use.
But that's irrelevant with this.
All right, look. Okay, are you going to let me be the judge and tell you what's relevant and what's not, or are you going to just take over the case? You want me to just give over and let you? You want the case? I'm not.
No, but you don't have to be rude to me. I mean, but I don't know what my children have to do with me driving on suspended.
I'm not going to stand here and let you, or sit here and let you talk down to me like that when you're the one that's accused of violating the law, and then you come in here with an attitude trying to tell me how it's going to be. Stop.
No, but you're bringing my children into it for why? My children have nothing to do with me driving on suspended. They have nothing to do with that. None of them cases do.
All right. Your objection is noted, overruled. Now then.
Okay, I'll just come back with my attorney.
All right. Are you hiring your attorney or are you applying for your court-appointed attorney?
I'm applying for the court-appointed one like I had asked prior.
All right. And you're going to go over and you're going to talk to Mr. Patterson. And I suspect the first thing he's going to tell you to do is show some respect for the court, whoever the court is. You don't have to feel respect for me, but you have to show respect for the
I am showing respect, but you're being disrespectful to me. Like, I feel like you're being very disrespectful to me.
Now, let's finish looking at this record. I've told you, you want me to make it a cash or surety bond? Because you're starting to show me an attitude that I don't know that you respect the court enough to follow the court's orders.
I do respect the court.
You just don't respect me personally. Is that what you're saying?
No, I do respect everybody. I respect the court, but I feel like I'm not being respected at all. And I'm not being disrespectful. I really am not. I'm just saying that when I object to like some of the things that you were saying, that's all I was saying. But I will keep my mouth shut and you can proceed and I will come back with my attorney, like court-appointed attorney. I apologize.
May I speak? And I'm being sarcastic and I shouldn't be. That's out of order. And I correct that. But you are provoking the court, Ms. Johnson, and you need to stop it. Now, pending, besides the case you have in front of me right now, you are charged with Sedgwick County District Court. You are charged in 2024 driving while suspended. That's still open. You've got a Harvey County case. Driving while your license is canceled, suspended, or revoked. Driving without insurance. Familiar? That's what you're looking at in Butler County.
We just actually found out about those two cases today when I called to see where my court was today, because I didn't know about the one that I didn't know I had two open cases and one in Harvey. It's because I owe fines to it. That's it. And then the one in Wichita, Central County, I owe fines to it. That's the only reason they're open is because I still owe my fines. That's it. And I need to pay my fines.
So in addition to driving while suspended and driving without insurance after a prior conviction with 3 years, you have an open Harvey County case in addition to the Butler County one. Then you have the Greenwood, a limited case in Greenwood. You have a BU, that's Butler County, another, let me see, maybe that's, okay, that's the one here today. Yep. Have other things. 21 CR, criminal use of a financial card, theft of property. I'm sure you're going to tell me those have nothing to do with your traffic. But it tells me that you don't follow the rules, you don't follow the laws. Here's a traffic in 2018, speeding, operating without a valid license. 2015, driving without liability insurance. More civil matters.
And I have a question whenever you're done.
I'm not done. I've got to get past some of these matters. What county, Mr. Aguirre? I can't think of what county VA would be, but there's a criminal threat. Oh, there's a criminal damage to property 2013 and interference with law enforcement, criminal damage to property again, criminal threat. It's on your record, ma'am. You can talk to your attorney about it. But these are all matters and they keep going. There's a...
How far back do you guys, use that against a person? I thought it was like 7 years.
I don't know where you heard it 7 years that I can't use anything you've done after 7 years, criminally speaking, but I have never heard that law. They didn't teach me that in my law school. Maybe they did in yours, but not in mine. Ma'am,
I was just asking a question. You don't have to be rude. I was asking a question.
If you will let me, I'm really trying to stay calm and not find you in contempt. But the way you are sassing and disrespecting and arguing with the court puts you in a position where I could find you in contempt, order you to pay a fine, and actually order you to serve jail time. I don't know if you're aware of that from this long history, but let me tell you this. Your history, I can consider your criminal history as far back as you started committing criminal history and establishing it. Yeah.
Oh, I didn't know that. I didn't know that. I'm sorry.
Well, I'm sorry you didn't, but now you do know that when you started establishing a criminal history, it became a basis that future courts could look at to determine whether or not you're a risk to come back to court, whether or not you are at risk to the community to keep violating the law. And that is why I'm going through this record. I probably wouldn't have scrutinized it as much other than you've challenged me, you've questioned me. And so that's what I'm looking at. And I think it's very reasonable that the state recommended, and they've got more traffic matters, it sounds like, than I do. I'm just looking at your Odyssey state record that's through the state computer system. He has the whole official KBI, FBI records that I don't have. And from what he said, he has more than I do. And yet he has restrained himself to recommend only a $3,500 OR bond. And because he recommended that before, but turn off whatever it is you're causing feedback, whatever you're recording me on. Because
I'm not recording you on anything, ma'am.
I have a very busy docket, ma'am. I really need to get on. This isn't fair to the other people that are politely waiting their turn.
Okay, but why did you accuse me of recording you? Because I'm not recording you at all.
You turned on a TV, you turned on a computer.
I don't have a TV in my home. I don't have a TV in my home. Would you like to? I don't. I really didn't turn anything on. I'm sitting right here and I don't have a TV. I don't own one.
Ma'am, you started causing feedback. Your recording device started causing feedback, and that is usually because someone turns on another device. All right, Miss, I have got to get on with that. Would you just stop and listen to me?
Yes, but I didn't do anything like you're accusing me of. I really didn't.
Okay, one more response like that, and you're going to be found in contempt, and I'm going to issue a citation to have you picked up and put in jail. Please do not force me to do that. I don't have time to do the paperwork to do that today. You can see this docket. I've got a full afternoon docket, and I want to give everyone their due rights today and their due hearing. All right, now, your bond is set. No arguments allowed at this point. $3,500. OR. You will go into a breakout room as soon as this hearing is over. There will be an invitation to a breakout room flash on your screen. You will go into the breakout room with court security too. They will set up a time with you to go out to the jail and take care of your picture, your prints, and post that OR bond. You do not have to take the money with you, but you have to sign a document that if you don't come to court and do what you're supposed to on that bond, you can forfeit that bond, causing the money to end up in the state's hands, and you can cause a warrant to be issued for your arrest. So that is your bond. And tell me again, Jenna, her next court date.
Your Honor, I have January 12th at 8 a.m.
You must come back January 12th, 2026 at 8 a.m. with your attorney and ready to proceed. Mr. Regier, is there anything else I need to address?
No, Your Honor.
All right, Ms. Naxted, anything, or I'm sorry, Ms. Johnson. Ms. Johnson, anything else you want to take up before I let you go?
No, Your Honor.
All right, then I suggest you call Darren Patterson, your court-appointed attorney, and let him know what's gone on today.
I will. Thank you.
You're welcome. And put your face back on your screen. Where did you go?
I'm right here.
All right. And next time I see you, next time you see any judge, and you've seen a lot of them over the years from this record, next time you see any judge, you need to show the judicial process a better appearance, a better kindness, a better courtesy than what I've seen today. Maybe you think it's courteous, but it's not, trust me. All right, you may go at this time, Ms. Johnson. You are excused from today's proceedings. Continued on that bond.
Your Honor, does she have to be in a breakout room before she goes on?
Yes, she does, please. Ms. Johnson, no, you're leaving me, but you're not leaving the recordings. Go see the court security officer. Thank you, Jenna.
You know, some days it just doesn't pay to be a know-it-all smartass. And that was one of those days for that lady. You know, I just don't have much I can say after that. It has been an amazing show, ladies and gentlemen. I want to thank everybody for hanging out. Zach, thank you very much for your support earlier in the stream. That was greatly appreciated. Everybody who's been in here chatting with me this morning, this afternoon, greatly appreciate. The chat's been amazing. The first case that we watched today, man, that was a divisive one, and that's one that everybody's going to have their opinions on, and I welcome all of them, and we need to see all of those opinions in the comments. I want you to like and subscribe. Maybe think about turning on the bell icon. Keep an eye out for more of the videos that I have coming out, because I got a lot of videos coming out, ladies and gentlemen. I've got tons of stuff on the cutting room floor, and it's just waiting to be packaged up and published. So, ladies and gentlemen, thank you for hanging out with me this morning, this afternoon, day. And thank you for participating in the chat and helping me get these videos published and put out. I am your Lone Wolf Usul. I am your host for this here Court Gallery Review. I am your curator for this channel, and I got nothing else. I have got to go take some flowers in, or I've got to take some plants in, because it's going to be really cold next week. Be weather aware, ladies and gentlemen. The temperatures are about to plummet like the prices at Fred's. If you remember Fred's, because that's something everybody definitely does. Ladies and gentlemen, thank you very much for your attention today and your patronage here on this channel. We'll see you next time. We'll be doing something just like this, similar, every night of the week around 8 p.m. Central Standard Time. Is it Central Standard? 8 p.m. Central Time, 9 p.m. Eastern. Live chat, lots of court, all day, every day. Come by and see me, lady. It's been great. Keep your eyes to the skies and keep your butts out of jail, because if you get in trouble, we might be watching.